and we have filed first appeal in this honorable court.
That's right.
One
But you
IA
have
is
never
also-
mentioned it.
One
Did you
I-
mention it earlier?
No mention.
So,
One IA is also there for
so on
stay.
19th you mentioned it. Can't do anything.
May I mention?
Prayer rejected.
This case from
Prayer rejected.
Delhi item 4, second
I will
appeal
not grant
187 of 2008.
Not on the.
I will not grant time in such old cases. ये वाला है ना? हम टाइम नहीं देंगे इसमें।
परिवार में डेथ हुआ है, अगर हमको
किसके
जाना है-
परिवार में?
मेरे बड़ी मम्मी का डेथ है, इसलिए मालूम नहीं।
अच्छा। कब चाहिए?
10 days के बाद।
आप बताइए। Your counsel will be available. You have seen the records. (21st) I'm asking him, there is a death in his family.
22nd.
22nd. Nikki, essay number 187 of 2008. The learned counsel for the appellant seeks adjournment on account of bereavement in his family. At his request and with the consent of the parties, consent of the respondents, the matter is directed to be posted on 22nd of January to be taken up as first case at the tribunal. कोई adjournment का slip मत दीजिएगा please. I am fed up with this adjournment.
रात में मैसेज आया तो
हम बता दें आपके डेट के हिसाब से आपका डेट फिक्स हुआ है. मिस्टर लैंग विल बी अवेलेबल. कितना मुश्किल से मिस्टर लैंग को तैयार किए हैं केस आगे करने के लिए. समझ गए?
हम लोग भी तैयार हैं कि बट
Lordship, there's a direct judgment when he said that before 1956 and 1937 also, daughters and wife had a right to the survival, inheritance. They had a right to the inheritance if they were Mitakshara.
You see Vinita Sharma.
Yes, with Mitakshara.
So, finally, so item 1, second appeal 498 of 1993.
Where is the respondent? He was supposed to provide us the number of SN.
Yes.
He is not there. We will not adjourn it. We will hear it. Because SLP का filing का कोई evidence हमारे पास नहीं है. Nothing is mentioned. Argue with this. Substantial question of law.
But order number 75. It is 29/10/2025.
Order number
75.
75.
Yes. अपने पास तो कॉपी मिली है.
ये देखिए. ये है order sheet. Memo of appeal से भी ज़्यादा
Yes,
मोटा.
by last order that
Yes, sir.
substantial addition, substantial question of law was formulated.
This is one additional substantial.
Additional question.
What was the main question?
Main question was dated 28/2/1990. Order number 6.
Order number 6. Yes.
Yes. Number 1 was whether a suit for declaration of title and conservation of project is maintainable after expiry of 12 years from the date of declaration of possession passed in the proceeding under section 145 CRP. Next, whether the relation of after.
नहीं ये नहीं है. Whether the suit filed by the defendants for declaration of title is maintained. दो और करके है. दो और करके क्यों बना है?
और करके नहीं है मैडम, दो.
हाँ. नहीं इसमें और whether the suit filed by the defendants for declaration of title is maintainable after lapse of 12 years of declaration of possession.
This is the first.
Okay.
Next is,
इसी ऑर्डर में.
it was same order, 28 to 1994.
एक है 23 to 17. 28 sorry.
Order number 6, it is 28 to 2 है ना, 1994.
Just. हाँ ठीक है. That's right.
The first one, whether
I've read it.
And
Second
then-
बताइए second. Whether the
relation of upland of equal status will inherit the property simultaneously in absence of relation of full blood. These were the two substantial questions of law formulated at the time of conviction.
they are governed by which law?
Where Shia model,
That's fine. And there is another order passed by this
Yes.
court.
additional substantial question was formulated.
This the first substantial question of law was modified
Modified.
by the order dated 23 to 17.
Yes, yes.
So that also we have seen. And additional substantial question of law. Whether the decree.
Order dated 29/10/2022.
Yes.
The last paragraph में कर लेंगे. Paragraph 10. Considering the context involved in the present case, the court is of the considered view that aforesaid additional substantial question of law as proposed through the interlocutory application does arise for consideration in the case. Accordingly, the additional substantial question of law is framed as under. Whether the decree passed in title suit number 6 of 1976 is void, collusive, inoperative, and was not binding upon the plaintiff.
Okay. Now let us see the judgment. Yeah.
Lord, plaintiff is before your lordship. Plaintiff responded. When the plaintiff has got knowledge,
Suit was decreed.
suit was decreed, and appeal was given. Appeal was allowed by the defendant.
What is the title suit number?
Title suit number 2 of 1985. Mirza Abed Hussain.
1985.
1985.
First, I would like to see the plate and the
Yes. That since it is an old document, therefore there are some hazy drafting, hazy signing.
No,
May
I have the
take-
original.
Then may I take help of a
Yes,
pen?
yes,
You
sure.
will read it out.
Sure, sure. You can also point out the relevant statements in the plain and the written statement which would have a bearing in this matter.
But a similar case in between the parties is pending and is not fixed for tomorrow.
Similar case.
131 of 1998.
Essay,
98 P.
essay 131 of
98 P. In which period the
1998 P.
P. In which period the respondent has disputed regarding wives of Mirza Walayat Hussain, the common ancestor.
That's right. It is between the same parties.
In between the same party, same family, Walayat Hussain was the common
With
ancestor
respect to the same property.
with respect to different property. But the parties are same.
That's right. Property parties could be same, but genealogy is not in dispute in this appeal.
Not in this.
In
not
that appeal, it
in
must.
that
We are not bothered about.
Yes.
We are only concerned
Now
with
case of the plaintiff is that Mirza Walayat Hussain had only two wives. Oh. Okay. Well, this is the terminology.
Yes. Mirza Vilayat Hussain had two wives.
Two wives, Walayat Khatun and Jamruti Begum.
Yes.
From Walayat Hussain, Mirza Yusuf Hussain was only son.
Yes.
He had two wives, Walayat Nisa and Hasmi Begum. From Walayat Nisa, he had Mirza Ashraf Hussain. And from Hasmi Begum, he had Mirza Yasuf Hussain, alias Chando Mia, who died prior to Hasmi Begum.
He died
Prior to his mother. His mother was alive. Now, Walayat Hussain had got a son, Mirza Ashraf Hussain.
This Mirza Yaqub Hussain, he
Died.
died
Prior to his mother.
prior to his mother, Hashmi Begum.
Hasmi Begum.
And what is Amzadi Begum?
Amjadi Begum is wife of Mirza Ashraf Hussain, son of Mirza Yusuf Hussain.
Okay.
वो लगता है ये गलत निकाल दिया कि प्रीडिसीज्ड हर मदर जो है ये चांदो मियाँ के बारे में
अच्छा,
वो गलत ट्रेसिंग हो गया।
ठीक है, इसको हटा दें।
हाँ, उसको काट दिया।
चांदो मियाँ तो मेल है ना?
चांदो मियाँ died prior to his mother. Her mother died subsequently, and the entire property vested in heirs of Mirza Yusuf Hussain. Mirza Yusuf Hussain had one son. We had two sons, one died and one left.
मिर्जा
Ashraf.
यूसुफ हुसैन के तो बच्चों के बारे में इसने कहीं लिखा ही नहीं।
मिर्जा यूसुफ हुसैन ऊपर में देखा जाएगा, वलायतुल हुसैन का ओनली सन,
हाँ,
वलायतुल खातून का,
विलायतुल खातून का
अशरफ मियां ओनली सन.
ठीक है, ओनली सन। ओके,
And he had two wives. Ashraf Hussain
Ashraf
had two
Hussain
wives.
had only one wife, it is showing. एक ही wife,
And
Amzadi Begum.
Amjadi Begum is wife of Ashraf Hussain.
Yes.
And now we let Amjadi Begum had only one daughter, Bibi Amirun Nisa,
Okay.
who predeceased her mother,
Okay.
leaving behind 3 daughters, out of which one daughter had died. And these 2 daughters are dependent number 1 and 2.
Who are the plaintiff?
Plaintiff was from right Jamuti Begum, was had son Mirza Jainuddin Hussain. Jainuddin Hussain had wife Aliman Bibi, and his son Mirza Abid Hussain was plaintiff. After his death, his heirs were substituted.
इसको लिखिए.
Now we were
सर इसको लिखते हैं. ये आपका ये genealogy लिखते हैं. The learned counsel for the appellant has submitted that plaintiff is the appellant before this court. The suit was decreed and the appeal was allowed. The case arises out of title suit number 2 of 1985. He submits that as per the plaintiff. इसका genealogy में इसमें कोई dispute है?
इसके जिंदगी में जितने भी
ये तो सुप्रीम कोर्ट में फाइल हुआ है बात बोले
तो आप आधा घंटा से क्यों नहीं आए?
जाम था मेरा
जाम था तो क्या करें? कोर्ट बंद कर दें? ये कोई एक्सक्यूज है? हम इनको आधा घंटा से सुन रहे हैं, ठीक है? आधा घंटा नहीं तो 20 मिनट से तो जरूर सुन रहे हैं और आपका कुछ अता पता ही नहीं है. नंबर दीजिए केस का.
फाइल की
लिखिए तो इस केस में केस का नंबर डालिए. The counsel for the respondent has submitted that the SLP has been filed against the order framing additional substantial question of law on 5/1/2026 with diary number 41926 of with diary number 4192026. He seeks adjournment. कब का डेट चाहिए? At his request, the matter is directed to be posted on 9th of February. Office to track the status of their proceedings. Counsel for the respondent is also directed to intimate this court about the status of this.
Item 2, second appeal 185 of 1995.
Appellant. Yes. First, you show me the subscription of law, and you are the plaintiff or the defendant. You just tell me.
ये प्लेटिव थे। एक बात जो इसमें क्लियर होगी, ये संभवतः ये केस डिसमिस फॉर डिफॉल्ट हो चुका था, क्योंकि एक ऑफिस नोट से लगता है, उसको काइंडली देख लिया जाए। आई एम सॉरी दैट आई कुड नॉट एग्जामिन द फाइल मायसेल्फ, थोड़ा सा बाहर चले गए थे, उसको देख नहीं सकते। इसमें देखा गया है 30/4/2003 का ऑफिस नोट, कि प्रेमटी ऑर्डर था इनको दरखास्त देने का एप्लीकेशन 25/2 से 25/2/2003 को, लेकिन इनका नहीं वो दरखास्त फाइल हुआ, जिसके चलते कि डिसमिस को डिफॉल्ट हो गया। ये कह रहा है सब्स्टिट्यूशन पिटीशन एडमिनिस्ट्रेटेड बाय कोर्ट ऑर्डर डेटेड 25/2/2003 कहा था इनको दाखिल करने के लिए, फाइल नहीं किया, प्रेमटी कंप्लाई नहीं हुआ तो ऑटोमेटिक डिसमिस हो गया। Submitted before the bench for consideration and necessary orders as to whether the whole appeal has become infructuous.
We'll see that also.
जो
We'll see that also. Whether the whole appeal has.
इसलिए हमारा कहना है कि वो पहले देख लीजिए before your lordship proceed, उसको काइंडली देख लीजिए। हम नहीं देख सके, आई एम सॉरी फॉर दैट।
हम ही देखेंगे, आप चिंता नहीं कीजिए, आप बैठ जाओ। नहीं देख सके तो
हम
कुछ कर नहीं सकते।
I was away from here for 2 days.
1995 से ये मैटर चल रहा है सर।
जज नहीं, हमको उसको कुछ नहीं करना है, हमको केवल ये हम चाह रहे थे कि सोचे थे कि पहला वो जो एक फिक्स केस चलेगा तो देख लेंगे तब तक।
आप ही का ना केस था पहला फिक्स केस?
नहीं ये नहीं, फिक्स था आपका।
जो एक फिक्स था वो आप ही का केस था, जिसमें
वो
एसएलपी
मेरा
फाइल,
नहीं, वो नहीं।
आप ही का जूनियर टाइम
नहीं,
एसएलपी नंबर दिए।
एक नंबर में हम लोग हैं, एक नंबर नहीं, 4 नंबर।
4 नंबर में आप नहीं है, आप ही तो दिए हैं सर।
नहीं,
पहला नंबर में
अभी जो एजेंट हुआ,
हाँ 498 पटना का।
हाँ, तो और कौन सा केस चलेगा?
ये दूसरा केस जो है पहले के बाद दूसरा ही मेरा ही है।
बहुत अच्छा
जी, उसको काइंडली देखिए। उसका कंप्लाइंट
ठीक है। रेस्पोंडेंट नंबर 1 के अगेंस्ट में आपका अभी अपील अवेटेड है। ठीक है,
नंबर 1 पे हुआ, क्योंकि मेरा दूसरा सबमिशन हुआ उसी का मतलब होल केस जो है इसमें नोटिस, ये जो आपका ऑफिस नोट है वो मेरा कहना है कि वो सही है कि होल केस इंफ्रुक्चुअस होगा।
तो आप फिर पहले आप बहस करिए कि पहले ये बहस करिए?
इन्हीं को करना है, अपील तो इनका है।
नहीं, अपील इनका है,
अपील जो
लेकिन
पॉइंट था,
जब आप बोल रहे हैं कि होल केस अवेट हो गया है तो ये तो आप ही को ना सुनेंगे फिर
जी हाँ,
पहले
जी हाँ,
तो आप बहस करिए।
होल केस एवेट इसलिए हो गया अभी, क्योंकि जो इनका
नहीं, बिना केस रिकॉर्ड देखे तो नहीं बोल पाएंगे ना। फिर आप हमको बताइए कि उनका क्या स्टेटस था जिनके अगेंस्ट में आप बोल रहे हैं कि होल
ये
केस अवेट?
प्लेंटिफ है, प्लेंटिफ यहाँ पर जो है सो एपेलेंट है, प्लेंटिफ का सूट अलाउ हुआ।
रिस्पोंडेंट, एक सेकंड सर, रिस्पोंडेंट नंबर 1 कौन थे? व्हाट इज द नेम ऑफ रिस्पोंडेंट नंबर 1? एक्सपंज हुआ है ये, उसके बाद में ये ऑर्डर जो है ऑर्डर 14/7/2009, उसके बाद एक ऑर्डर ड्रॉ हुआ है 14/7/2009।
बाबूलाल
सर आपने 14/7/2009 भी एक ऑर्डर हुआ है 14/7/2009
2009
जी।
आज इसको हम
नहीं एजेंट करेंगे
हमको
सर,
रिकॉर्ड देखना दिया जाए, कर
हम
रख
एजेंट
लीजिए,
नहीं करेंगे सर।
कर रख लीजिए सप्लीमेंट्री में, हम जैसा रिकॉर्ड देखना चाहते हैं।
सर आप हमको ये बताइए
जी
कि इस तरह के सेकेंड अपील को काफी रिकॉर्ड पढ़ के आना पड़ता है ना, ये तो ऑर्डर शीट तो हम नहीं देखे हैं, तो जो हम 2 घंटा आपके रिकॉर्ड
हम
को
तो
पढ़ने के लिए
हम
लगाए,
तो कह चुके
तो
कि
कौन सा फाइल हम ले लें जो हम बिना पढ़े डिसाइड कर लें?
हम मीटिंग के सामने तो शुरू में कह दिया, आई एम सॉरी,
नहीं,
इसलिए कि
आपका
सॉरी इसलिए है कि हम उसको
सर आपका वो नहीं बोल रहे हैं।
जी,
जब आपने ये ऑब्जेक्शन रेज किया है तो हम लोग एग्जामिन कर रहे हैं, तो कर रहे वी आर एग्जामिनिंग।
तो वो यदि देख लिया जाए उसको कि वो प्रेम्प्टरी ऑर्डर था, यदि वो कंप्लाई नहीं हुआ तो सर्टेनली वो डिसमिस हुआ। अब डिसमिस हुआ तो वो होल अपील डिसमिस होगा। मेरा सबमिशन इसलिए होगा कि कॉज ऑफ एक्शन जो है सबके खिलाफ एक ही है। वो प्लेंटिव चाह रहा है डिक्लेरेशन इन हिज फेवर कि ये जो डीड ऑफ एडॉप्शन है उसके आधार पर मेरा राइट एक्रूव करता है ऑन द सूट एज बीइंग द एडॉप्टेशन ऑफ मुंशी। वो अपील एबेट करेगा मेरा भाव, इसलिए हम थोड़ा उसको चाहते थे तो उनको कष्ट देने से अच्छा होगा कि हम कल है बहस करने के लिए तैयार हैं, उसको ज़्यादा टाइम भी नहीं लेंगे
आज इनको सुनते हैं ना, आज अभी आपका नंबर ही कहाँ है?
अच्छा ठीक है, जैसा जैसा देख लिया।
उतना देर में आप देखिए। देखिए रिस्पोंडेंट नंबर 1 के अगेंस्ट में तो आपका अपील अवेट है, ठीक है, एंड हिज नेम हैज ऑलरेडी बीन expunged, correct? And नहीं, respondent number 1 के अगेंस्ट में अवेट हो गया है बाबूलाल मुर्मू। He had 2 full brothers on record. One was Barsong Murmu and other was Doda Murmu. They were respondent number 2 and 3. And respondent number 2 has been substituted. Right?
इसमें हमको कहना है कि इनका इंटरेस्ट ऑलरेडी इन्वॉल्व है अदर रिस्पोंडेंट के साथ, यदि जीतते हैं उनको तो हो ही जाएगा, इसलिए वेट नहीं करते।
अब आप जो है इस चीज को ध्यान में रखते हुए सब्सटेंशियल क्वेश्चन ऑफ लॉ को एड्रेस करें।
क्वेश्चन फ्रेम किया हुआ है ऑर्डर नंबर 3 से डेटेड 23/1998।
और ये क्या सब्सटेंशियल क्वेश्चन है?
23/1998 This appeal is against the judgment of reversal issued in this correspondence for which the Tarvana DC must have been included and its stand rejected without the response. The following substantial question of law arises for the consideration. Whether the appellate court can doubt the genuineness of a valid registered deed fully proved by the scribe himself and found here valid genuine by the trial court. Second, whether the genuineness of the valid document can be doubted when the same has been otherwise fully proved only because the unifying and attesting witnesses have not been examined. Whether more mission to the mention particular date in the adoption regarding the adoption is put some year back, is invalid the deed.
अबेटमेंट वाले सारे जजमेंट्स एक जगह किए थे ना, अबेटमेंट वाले सारे लीजिए सब नया वाला जजमेंट है, इसको लेटेस्ट जजमेंट
2013 है, इसमें भी सुप्रीम कोर्ट का 2 डिसीजन करते हुए है, तो उसका इम्पैक्ट नहीं पड़ता है सबके खिलाफ, वो सब गठन होगा उसी से, वो सूत्र ये इसमें सुप्रीम कोर्ट का जो डिसीजन जो है AIR 1966 सुप्रीम कोर्ट पेज 1427
पार्टी ने
32
पार्टी ने
and
पैरा नंबर
32 AIR 2004 सुप्रीम कोर्ट पेज 394।
सर आपने पहला जजमेंट बताइए, पहले AIR 1966 सुप्रीम कोर्ट 1427 इसका पैरा नंबर
उसका
बताइए।
पैरा नंबर 32 और 33 मिला है
32 एंड 30 और दूसरा
AIR 2004 सुप्रीम कोर्ट
3942 पैरा
उसमें जस्ट
ये दोनों जजमेंट लाइक सजीव जी AIR 1966 सुप्रीम कोर्ट 1427 AIR 2004 सुप्रीम कोर्ट 3942 लिस्ट में और भी कोई जजमेंट है आपका? लिस्ट दिया हुआ ना आपने?
this year only
ठीक है, जितने ऐसा मंगा लीजिए। प्लेन से पढ़िए, प्लेन। The suit was for title suit number 4096. Just a moment, एक second रुकिए। ये प्लेट नहीं है, ये इंजंक्शन पिटीशन में प्लेट लगा हुआ है। ये है इंजंक्शन पिटीशन। सब मिसलिनियस वाले पिटीशंस हैं, इसमें और होगा तो मिसलिनियस पिटीशंस हैं। दोराई जी को बुलाएंगे, वो भी निकाल के बताएंगे। दोराई जी को जरा बुलाएंगे, बैंक स्टेटमेंट निकाल के बताएंगे। ये तो मैंने देखो मिल रहा है, वो इंजंक्शन का पिटीशन। रेंज में ना केस नंबर हमेशा हाथ से पड़ेगा। हाँ, टाइटल अपील है। समीर जी, टाइटल अपील नंबर
It is 4988.
Okay, you argue here. You argue here. You just give me the background of the case, or you can place it from the improved judgment. What was the suit for?
Declaring the plaintiff as legally adopted son of the Simurmu. Second, the declaring right title in case of the plaintiff in the suit line. The confirmation of the possession of the plaintiff in suit line in case the plaintiff is dispossessed during the pendency of the suit, the recovery of the possession of the plaintiff. Fourth, the degree for permanent injunction against the defendant first party. Cost of the suit is the order to the plaintiff. Need the relief the plaintiff is entitled.
So primarily the relief was whether the adoption was valid or not, and all are consequential relief.
Yes,
Correct?
yes.
What are the findings of the? What is the exhibited registered deed of adoption? Exhibit
One.
one.
And exhibit B by A is the affidavit.
Exhibit D by A.
B or B by A.
B and
Three by A. Three
yes, exhibit number
by A
3 by A.
is the affidavit
Affidavit of
the
exhibit.
Raska Murmu and Vijay Kasda.
Affidavit of
B by A.
are the affidavit of 3 and 3 by A.
Yes, ma'am.
Are the affidavits of
Then it is the
you just tell us for deciding this appeal.
Yes.
For deciding this appeal, which all exhibits and which all depositions are relevant, according to you.
Exhibit 5 is the
Exhibit 5
PCR
है
case
कौन
number. PCR case number 58.
सेकेंड अपील ऐसे नहीं आर्ग्यू करिए भाई.
That is document.
I'm just asking you,
The
which all exhibits will you be referring to? Just give me the list of exhibits which you are going to refer to offer the substantial question of law. Tell us which all exhibits.
Yes, ma'am.
Exhibit 1,
1. Yes, ma'am.
okay,
B,
and
B, 3 and 3 by A.
sorry,
3
and
or 3 by A.
according to you, exhibit 1, 3 and 3 by A.
A.
Yes, and what else?
And exhibit 2, revenue receipt.
वो प्लेन नहीं मिल रहा था इसलिए आपको. आपके पास काम है ना?
One is exhibited and two without any objection by the defendant.
Exhibit 2 is also without objection.
Yes, Lord, sir. 3 and 3 by A is also without any objection. 3 and 3 by A is without objection.
So all these documents were exhibited without objection.
Without objection.
Then three objection का.
Sorry?
नहीं.
Yes, sir, without objection दिया है, sir.
Without
They are all without objection. All
Without
the documents of the plaintiff have been exhibited without objection. Okay?
The contention of the defendant is property of the recorded Khatiyani region. Jharkhand is not partition within the brothers. So Manu Murmu and Mandan Murmu. But it is proved by himself by the defendant is partition.
There is a finding of partition.
Finding of partition, evidence of the defendant is also.
Sorry?
Evidence of the defendant is also partitionally right.
That is not that is not the substantial question of law. जो substantial question of law है आप उस पर बहस करें.
So I reading the evidences of the judgment of the trial of the university. Decided in the favor of the plaintiff.
Read it.
यह बात घोषित करने के लिए कि वादी मुंशी मुर्मू पुत्र है और वादी जमीन पर उसका हक एवं स्वामित्व है। संक्षेप में वादी का वाद है कि वह बस संस्थान है अनुसंधानी परिवार द्वारा शासित है। मौजा तारापुर थाना मुंशी जिला साहिबगंज के नौबंदी नंबर 10 का खतियानी एरिया उनका मामला है और यह जमीन हस्तांतरित स्वरूप का है। उनका मुर्मू अपने 3 लड़के सिंधु मुर्मू मालूम मुर्मू और मंडल मुर्मू को छोड़ने के बाद मिला है। सिंधु मुर्मू अपने एक लड़का जेठा मुर्मू और मालूम मुर्मू अपने एक लड़का मुंशी मुर्मू को छोड़कर मर गए। मंडल मुर्मू अपने 2 लड़के रस्का मुर्मू और गुरु मुर्मू को छोड़कर मर गए। बाद में प्रतिवादी द्वितीय पक्ष है और जेठा मुर्मू अपने 3 लड़कों को बाबू लाल मुर्मू, हर्षण मुर्मू और लुदा मुर्मू को छोड़कर मर गए। ये तीनों बाद में प्रतिवादी 1, 2, 3 है। मुंशी मुर्मू का बाल बच्चा नहीं था, उसकी पत्नी भी मर गई थी। तब मुंशी मुर्मू ने अपने संपत्ति की देखभाल के लिए रस्का मुर्मू के 3 लड़कों में से सिद्धू मुर्मू को प्रस्तुत बनाने के लिए निवेदन किया, जिससे रस्का मुर्मू ने स्वीकार कर लिया। तदनुसार मुंशी मुर्मू ने सिद्धू मुर्मू को संथाली रीति रिवाज के अनुसार प्रस्तुत बनाया। इस प्रकार से सभी रिवाज जैसे लेवेद, आचूर, निंदा, मंडी वगैरह किया गया। इसके लिए मुंशी मुर्मू ने दिनांक 14/6/73 प्रस्तुत नामा दलील नंबर 44 रजिस्ट्री कर दिया। प्रस्तुत बनने के बाद से वादी मुंशी मुर्मू के घर में रहने लगा और उसे एवं उसकी संपत्ति का देखभाल करने लगा। जमाबंदी नंबर 10 में मुंशी मुर्मू अपने हिस्से के जमीन के को अलग से दखल करता था। मुंशी मुर्मू 1978 में मर गए। उसके मरने पर वादी पुष्प के नाते मुंशी मुर्मू की जमीन को उत्तराधिकार किया, जिसका विवरण दस्तावेज के अनुसूची पर दर्ज है। वादी मुंशी मुर्मू का पुष्प होने के नाते उसके जमीन को दखल किया। वादी का विवादी जमीन का हक, समय एवं दखल है। वादी मुंशी मुर्मू की माँ रानी मरांडी का देखभाल कर रहा है, जो वादी के साथ मुंशी मुर्मू के घर में रहते हैं। प्रतिवादी प्रथम पक्ष एवं द्वितीय पक्ष का विवादी जमीन पर हक एवं स्वामित्व नहीं है। प्रतिवादी प्रथम पक्ष के 1985 में विवादी जमीन के दायरे पैदा किए, तब वादी ने दफा 44 भारतीय संहिता का केस नंबर 472/85 दायर जो एसडीओ के पाकू आदेश दिनांक 12/5/86 द्वारा प्रतिवादी प्रथम पक्ष के विरुद्ध निष्पादित हुआ। प्रतिवादी प्रथम पक्ष ने विवाद जमीन के उस जमीन से धान काट कर ले गए। तब वादी ने धारा 379 143 भारतीय दंड संहिता के अंतर्गत फौजदारी केस किया। केस नंबर 118/86 दायर किया, जिसमें दिनांक 15/6/88 को प्रतिवादी प्रथम पक्ष को सजा हुआ। प्रतिवादी प्रथम पक्ष विद्युत एसडीओ पाकुड़ के समक्ष राजस्व विवाद संख्या 77/85/86 विवादी जमीन को नापित करने के लिए दायर किया, जिसे न्यायालय ने वादी के आपत्ति पर दिनांक 26/10/88 को खारिज कर दिया। प्रतिवादी प्रथम पक्ष ने फौजदारी एवं राजस्व न्यायालय के आदेश के बावजूद विवादित जमीन को आधा हिस्सा को दखल करने की धमकी देते हैं। इसलिए वादी ने अपने हक एवं दखल को घोषित करने के लिए वर्तमान मामले दाखिल किया है। प्रतिवादी प्रथम पक्ष का संक्षिप्त में बात है कि वादी का वाद चलने लायक नहीं। वादी को वाद हेतु नहीं है और वाद में क्या समाधि है। प्रतिवादियों के बाद पत्र के खंडिका 1 से 3 को अपने कथन की स्वीकार किया है, किंतु कहा है कि वादी उनका मुर्मू का परपोता है, दस्तक परपोता नहीं है। खंडिका 8 को स्वीकार करते हुए प्रतिवादियों का कहना है कि मानव मुर्मू उनके मरने के बाद उसकी पत्नी रानी हेमरम अपने देवर मंडल मुर्मू से शादी कर ली और प्रतिवादी रसिका मुर्मू और बोड़ो मुर्मू का जन्म हुआ। प्रतिवादियों ने वाद पत्र की खंडिका 5-8 तक के तथ्यों के स्वीकार किया करते हुए कहा है कि मुंशी मुर्मू नावल और उसका देखभाल उसकी मां रानी हेमरम और औपचारिक प्रतिवादी करते थे। रसिका मुर्मू को अपने बेटे को गोद लेने के लिए निवेदन नहीं किए और न रसिका मुर्मू राजी हुआ था। लेवेद अचूर निंदा मंडी रिवाज पालन करते हुए मुंशी मुर्मू ने वादी को गोद नहीं दी है। पुष्पित नामा दलील 44 दिनांक 1473 जारी है। इस दलील पर गोद देने का दिन तारीख निवित अचुनिका मंडी इत्यादि रिवाजों का पालन करने का जिक्र नहीं है। संथाली रिवाज के अनुसार बड़े लड़के को गोद नहीं दिया जाता है। वादी 10 का मुंह का बड़ा लड़का है। यही तत्ववादी को गोद देने की बात को असत्य कर दिया है। दलील नामा नहीं है बल्कि एक घोषणा पत्र है। इस पर ग्राम पदाधिकारी एवं रसका मुर्मू का हस्ताक्षर नहीं है। मुंशी मुर्मू ने अपने वादी को गोद नहीं दिया, इसलिए इसके घर में रहने एवं उसको एवं उसके संपत्ति को देखभाल करने का सवाल ही नहीं उठता। प्रतिवादियों ने पंडिताना के कथन को इनकार करते हुए कहा है कि झुमका मुर्मू की जमीन व मंदिर नंबर 10 का बंटवारा उनके 3 लड़कों के बीच में नहीं हुआ था। यह संयुक्त संपत्ति है, किंतु उनके तीनों लड़के अपने अपनी सुविधा के अनुसार जमीन को अलग अलग दखल करते थे। इस तरह से मुंशी मुर्मू का अलग से जमीन नहीं था। मुंशी मुर्मू की मरने के बाद वाद पत्र की अनुसूची पर वादी तीनों के प्रतिवादी जमीनों को प्रतिवादी में प्रतिवादी संयुक्त रूप से उत्तराधिकार की और सुविधानुसार आधा जमीन को दखल करते हैं। इस जमीन पर वादी का हक एवं दखल नहीं है। वादी को मुंशी मुर्मू को गोद नहीं दिया। खंडिका 10-11 के कथनों के संबंध में प्रतिवादियों का कहना है कि प्रतिवादी जमीन पर प्रतिवादी एवं औपचारिक प्रतिवादी का संयुक्त अधिकार है और इसे भी सुविधा के अनुसार बिना बंटवारे के आधा दखल करते हैं। नारी हेमरा अपने लड़के औपचारिक प्रतिवादियों के साथ रहती है, वादी के साथ नहीं। वादी जमीन पर हक दखल नहीं है। प्रतिवादियों का कहना है कि दफा 144 सरकारी न्यायालय का आदेश का निर्णय दिवानी वाद में अस्वीकार है। प्रतिवादी गण दुमका में सजा के विरुद्ध अपील दायर किया है। राजस्व न्यायालय ने समझ किया गया प्रतिवादियों का दावा सही है। वादी जमीन पर हक दखल नहीं है। वादी बाद में प्राप्त करने का हकदार नहीं है। प्रतिवादियों के वादी के अन्य सभी तथ्यों को स्वीकार किया है और निवेदन किया है कि वादी की बात को खारिज कर दिया है। औपचारिक प्रतिवादी ने भी न्यायालय में उपस्थित होकर लिखित प्रतिकरण दाखिल किया है। औपचारिक प्रतिवादियों ने वादी के संपूर्ण वाद को स्वीकार करते हुए कहा की जमीन जमा मंदिर नंबर 10 मौजा तारापुर का बंटवारा उनके तीनों लड़कों के बीच हुआ था और वे अलग अलग एक तिहाई जमीन को दखल करते थे। इन प्रतिवादियों का यह भी कहना है कि झुमका मुर्मू के लड़के मानू मुर्मू के लड़के मुंशी मुर्मू का दखल कब्जा नहीं था, इसलिए मुंशी मुर्मू को वादी को गोद दिया। मुंशी मुर्मू की मरने के बाद वादी ने उनकी जमीन को पुष्पुत्र के हैसियत से उत्तराधिकार किया। वादी जमीन पर हक एवं दखल है। प्रतिवादी प्रथम पक्ष की ओर से दाखिल किया गया लिखित प्रकरण गलत एवं झूठा है और वादी के बात के निष्पादन के लिए वह पक्षों की तथ्यों के आधार पर निम्नलिखित वाद पद निर्धारण किया गया। क्या बात चलने लायक है? क्या बाद में तामीद है? क्या वादी को बात करने के लिए बात हेतुक है? क्या विवादी जमीन पर वादी का अधिकार एवं हक है? क्या संबंधित पुस्तक दलील 44 दिनांक 1473 वैध एवं अनुपालनीय है? क्या संबंधित पुस्तक दलील जारी एवं अनाती है? क्या वादी मुंशी मुर्मू का वैध एवं पुस्तक है? क्या वादी उनको प्राप्त करने का अधिकार है? मंतव्य वाद
See, these are the discussions. Thereafter, they have the discussions of the evidences, right? The plaintiff had supported his case. Now, since you are the plaintiff, right, you read the defense of the defendants because they are opposing you. Padi, para number 5. 16, page number 16. Page 16. पैरा 5 ही है शायद, 5 9 है, पैरा 9।
प्रतिवादियों की ओर से उनके विद्वान अधिवक्ता अपने बहस के क्रम में व्यक्त किए हैं कि संथाल में बड़े लड़के को गोद नहीं लिया जाता है। वादी रस्का मुर्मू का बड़ा लड़का है। प्रतिवादी के विद्वान अधिवक्ता ने बहस के क्रम में यह भी व्यक्त किए हैं कि वादी का प्रकथन निविदा मंडी नहीं है, किंतु साक्ष्य में साक्षियों ने इस संबंध में कहा है जिसे स्वीकार नहीं किया जा सकता है। विद्वान अधिवक्ता यह भी व्यक्त किए हैं कि लोबे चूर एवं पुष्पुत्र लेने एवं देने का साक्ष्य नहीं है। वादी के बाद एवं वादी के साक्ष्यों के साक्ष्य को अवलोकन करने से ज्ञात होता है कि निंदा मंडी एवं निवेद साक्ष्यों के संबंध में वादी का प्रकथन है और साक्ष्यों ने इसे साक्ष्य के क्रम में साबित भी किया है। वादी नंबर 1 के साक्ष्य के अवलोकन करने से भी ज्ञात होता है कि साक्षी ने अपने साक्ष्य में खंडिका 10 में कहा है कि बड़े लड़के को संस्थान में प्रस्तुत देने का नियम है। इस तरह प्रतिवादी के विद्वान अधिवक्ता के कथन को स्वीकार नहीं किया जा सकता। प्रतिवादियों के लिखित प्रकथन को अवलोकन करने से ज्ञात होता है कि प्रस्तुत लेने और प्रस्तुत देने और लेने के नियमों के संबंध में प्रतिवादियों का प्रकथन नहीं है। पादी संख्या 6 के साथ खंडिका 4 को अवलोकन करने से ज्ञात होता है कि संथाल में पुष्प देते समय हिंदुओं का जो रिवाज है वैसा नहीं होता है। इसके साथ ही प्रतिवादी देते और लेने संबंधी नियम को समादेश बीबीसीजे 1966 पेज 280 के अनुसार नहीं उठाया जा सकता है क्योंकि यह उसका प्रकथन नहीं है। इस तरह प्रतिवादी के विद्वान अधिवक्ता के कथन को स्वीकार नहीं किया जा सकता है।
ये presentation 1977 बीबीसीजे 280। आगे बढ़ी। पैराग्राफ
प्रदर्श 1 पुष्पनामा है। प्रदर्श 3 A रस्का मुर्मू और विजय हिंदम का शपथ पत्र है। उनका 2 कागजातों के संबंध में प्रतिवादी के विद्वान अधिवक्ता के बहस के क्रम में व्यक्त किए हैं कि दोनों का साक्ष्य नहीं दिया गया है, इसलिए इन दस्तावेजों को साक्ष्य स्वीकार नहीं किया जाएगा। वादी संख्या 5 का साक्ष्य है कि रस्का हेमरम एवं विजय हासदा बूढ़े एवं बीमार है, चल फिर नहीं सकते। प्रतिवादी के प्रतिपक्षण के क्रम में कहा है इन दोनों का उम्र 80-85 वर्ष होगा। इनके साथ से स्पष्ट होता है रस्का हेम्ब्रम और विजय हेम्ब्रम न्यायालय में आकर साथ देने की स्थिति में नहीं है। इस परिस्थिति में प्रदर्शन 3/3/A को स्वीकार करना न्यायोचित नहीं लगता है। दोनों प्रदर्शकों को अवलोकन करने से ज्ञात होता है कि रस्का एवं विजय हेम्ब्रम ने व्यक्त किया है कि मुंशी मुर्मू ने बुद्धू मुर्मू को गोद लिया है। प्रदर्श 5 58 में पारित किया गया निर्णय प्रतिलिपि है। अवलोकन करने से ज्ञात होता है कि प्रतिवादियों को उस केस में सजा हुआ था और इस केस में वादी ने दायर किया था। प्रदर्श 5/A इंग्लैंड मिसलेनियस नंबर 472/85 में पारित किया गया आदेश प्रमाणित प्रतिलिपि है। इसके अवलोकन करने से ज्ञात होता है कि इस केस में प्रतिवादियों के विरुद्ध
लास्ट में बोल दिया है कि ये सब ऑर्डर्स का कोई मतलब नहीं। Exhibit 2 has said that the plaintiff is paying the rent. 11 पढ़िए।
प्रतिवादी प्रथम पक्ष की ओर से अपने बात के समर्थन में कुल 13 साक्ष्यों प्रथम मोतीलाल
ये सारे नाम हैं।
किया है। इसके अलावा दस्तावेज साक्ष्य भी किया गया है। प्रतिवादी संख्या 2 प्रतिवादी संख्या 11 एक ही साक्षी है। इस तरह से साक्ष्य संख्या 11 के साक्ष्य को रद्द किया जाता है। प्रतिवादी संख्या 2 औपचारिक साक्षी है जिसे प्रदर्श 1 को परिचालित किए हैं। प्रतिवादी संख्या 6 के अंदर औपचारिक साक्षी है जिसने प्रदर्श को आवेदन पत्र को प्रकाशित प्रमाणित किया है। प्रतिवादी संख्या 8 की औपचारिक साक्षी है जिसके प्रदर्श विद्यालय प्रमाण पत्र को प्रमाणित किया है। प्रतिवादी संख्या 12 संथाली रिवाज के संबंध में साक्ष्य दिया है। इसका साक्ष्य है कि पुष्पुत्र का बाप नहीं होता है, पुष्पुत्र का बाप नहीं होता है जो उसे रखता है और पुष्पुत्र नाम रखने वाले बाप का होता है। इस साक्ष्य के साक्ष्य का बहस का महत्व नहीं है क्योंकि प्रतिवादियों का इस तरह से बात नहीं है। प्रतिवादी संख्या 1 का साक्ष्य है कि मुंशी मुर्मू के मरने के बाद अपने आधा जमीन को प्रतिवादी एवं आधा जमीन को रस्का एवं बोरो दखल करते हैं। प्रतिवादी संख्या
ये सारा डिस्कशन है इनके एविडेंस का। आप यहाँ पे आइए पैरा नंबर 14 पैरा 14 में आइए which is the
पक्षों द्वारा प्रस्तुत किए गए उपरोक्त साक्ष्यों के साथ तथ्यों परिस्थितियों एवं विवरणों के आधार पर मैं निष्कर्ष पर आता हूँ कि वादी अपने वाद को साबित कर दिया है। अतः मैं पाता हूँ कि वादी मुंशी मुर्मू का बैग हो सकता है।
आगे बढ़िए 15 नंबर पर जी पैरा 15।
प्रतिवादी की ओर से उनके विद्वान अधिवक्ता कहते हैं प्रदर्श 1 प्रस्तुतनामा जारी है। विद्वान अधिवक्ता ये भी व्यक्त करते हैं कि दलील में लाल बिहारी हेम्ब्रम पहचान करता है और उनका साक्ष्य नहीं किया गया नहीं दिया गया, इसलिए दलील प्रमाणित नहीं हुआ है। प्रदर्श 1 को अवलोकन करने से ज्ञात होता है कि यह निबंधित दलील है और इसे सिर्फ वस्तुत लेने के प्रमाण पत्र निष्पादित किया गया है और यह स्वीकृत तथ्य है कि दलील उस वस्तुत्र का दलील नहीं है। प्रदर्श 1 को वादी संख्या 3 व स्वयं इस दलील का लेखक है प्रमाणित किया है कि इस परिस्थिति में पहचानकर्ता के साक्ष्य की जरूरत नहीं है। प्रतिवादी द्वितीय पक्ष की ओर से प्रतिवादी संख्या 14 मनोहर मांडी का साक्ष्य दिया गया जो औपचारिक साक्षी है और प्रदर्श A1 लिखित कथन को प्रमाणित किया है। प्रतिवादी द्वितीय पक्ष ने वादी के वाद को समर्थन किया तथा उपरोक्त विवरणों के आधार पर मैं पाता हूँ प्रस्तुत दलील संख्या 44 दिनांक 14/6/73 वैध एवं अनुपालनीय है। इस तरह से तीनों बात पर वादी के पक्ष में निष्पादित किया जाता है।
Who was the scriber of this document? Who scribed the registered sale deed? So that is the first substantial question of government. Whether an appellate court can doubt the genuineness of valid registered deed fully proved by the scribe himself. Scribe is, who is the scribe? PW? Who is the scriber? कौन है? रस्का मुर्मू. Who is the scriber?
Father of the
Original father, the natural father of the plaintiff has been examined.
not again. That is,
So who is the scribe?
Examine, give it B1, B, 3 and 3 by 8. The affidavit.
Okay, which has been believed by the learned trial court. Who is the scribe of this? So on the basis of Exhibit 3 and 3 by A, it has been said that the deed was duly executed by him. Okay, trial court, appellate court judgment.
Yes, yes.
Yeah, appellate court का जो है ना main.
start from the para 5 years. At page 5.
Para 5. Yes, please read.
The Prathama defendant filed a separate written statement in which supported the plaintiff case of the adoption and his hating the property of the missing on his death by virtue of the 6. The pleading of the parties. The learned court claim issue 1 to 3, which are technical 1, concerning the validity of the suit. Issue number 4, 5, 6, 7. 4, 5, 7. The section 7 covered the broad question, namely whether the plaintiff has been validly adopted the missing he is the legally adopted son and of limited son of him, and whether the plaintiff has not right have got right title interest over the suit property. All the questions have been decided by the trial court in the favor of the plaintiff. The learned subordinate judge has held that the plaintiff is adopted son of the Mrs. Murmu, and for that sake the relied upon the posted deed of the adoption dated 14 73. Treating it as legal and genuine document of the adoption, he accordingly held other that the plaintiff on the death of the Munshi Guru has legally inherited his property, and so he has come in the possession thereof. With such finding, he decreed the plaintiff suit with respect to all the relief sought by him. It is against the judgment and decree of the trial court that the contested defendant first party has come up in the appeal here. In this appeal also, what new question arises for determination is as to whether the plaintiff is legally adopted son of Munshi Murmu. All other questions and are collateral ones centering around the basic question of the controversy. It is the plaintiff respondent who desired the court to give judgment to his legal status, and so onus lie upon him to prove the existence of fact that he has been adopted by the deceased Munshi Murmu and has acquired that status. The question of the plaintiff's right that is in possession over the suit land are absolutely dependent upon the question of the plaintiff being the adopted son Munshi Murmu, or if the fail to prove the adoption, he cannot claim Munshi property suit and as is conclusive here. Please mention here that the plaintiff has not pleaded in the plaint when that his adoption took place by the Munshi. As oral proof on adoption, he has examined 4 witnesses, including himself. They are W1 Shivsankar, Ravidas, Satan Mazda, Abdul Razak, Viswas, and 4 is the plaintiff himself. 8 is plaintiff himself. Besides this, the plaintiff has examined more witnesses. 3 more witnesses here. Evidences are most formal and not at all on the specific point of the plaintiff adoption. Besides the oral evidences, the plaintiff has filed the registered deed of adoption, Exhibit 1, said to be disputed by the Musi woman on Solar Jharkhand. PW1 and 2 are plaintiff co-bidders. Their common evidences is that Musi having no son had adopted the plaintiff's as son, and in the adoption ceremony, this was observed with all the necessary local customary function of the adoption like Nimda, Namdi, Achu. They were present to witness the same. PW1 disposed that Musi adopted the plaintiff about 17 years back, and after a year of adoption, Musi disputed the deed of the adoption in Exhibit 1. PW1 have further disposed that the plaintiff's birth name was Mandal. And then at the time of the adoption ceremony, there was a Namakaran ceremony also, and in that he was named as Buddhundu. They have further disposed that after adoption, the plaintiff came to be recognized as Musi's son, and after the latter death, he rented his property and came to possession thereof. PW3 is the scribe of the Exhibit 1, the registered deed of adoption, and he has also proved the exclusion of Musi. PW8, the plaintiff also on the court has supported his claim. Those part of PW5 has been examined to say that Raska Murmu, father of the plaintiff, and one Vijay Murmu are old man of 80 years and incapable to come to the court and depose, and their 2 affidavits, Exhibit 3 and 3/8, which supported the plaintiff case of adoption, have been tendered formally as the evidence for the plaintiff. These oral evidences are the 3W1 to 3 supported with the deed of adoption, Exhibit 1 and 2 affidavits, Exhibit 3 and 3/8, that the London Supreme Court has placed reliance on accepting the plaintiff case of adoption in between this history. But the London Council for the Plan defendant had several points to
You see, the ceremony, etc., have not been proved.
what will
There is, Mr. Counsel, बहुत ग्राउंड है आपका adoption deed को reject करने के लिए. The appellate court has given numerous grounds.
But the evidence is not objected by the.
What do you mean not objected?
the-
Merely because somebody's evidence on
Yeah.
affidavit is tendered, and that is not a substantive question of law. The substantial question of law is that if the scribe, it has been proved by the scribe. Scribe का commission क्यों नहीं किया? Yes, it has been proved by the scribe means who is the scribe? PW3. PW3 is the scribe. Now you tell us adoption is proved by the registered document or it is proved by actual performance of ceremony.
Actual performance of the ceremony.
Ceremony. So scribe से क्या होगा? Can he prove that? Can the scribe of a register? It is not a Hindu Succession Act. Hindu Adoption and Maintenance Act नहीं है ना? That there is a presumption. That presumption won't be there.
Their basis has been brought.
See, merely because there is a registered deed of adoption for Santhal, for parties governed by Santhal law, the presumption under Hindu Adoption and Maintenance Act will not be available.
Yes, Lord, but
In the adoption deed also the date of adoption is not mentioned. In the plaint also the date of adoption is not mentioned.
it is a formal.
What formal?
The performance of the ceremony
Is formal?
is the basic basis.
Is the
essential.
basis? Yes.
But documentation is not formal.
Documentation is formal.
Yes, Lord.
But the ceremony has not been proved.
Ceremony has proved.
Who has proved the ceremony? Show me the finding that the ceremony has been proved.
All the witnesses have been proved. Five
That is
items
not the
proved, himself
substantial.
20 by so proved.
You see, the first substantial question of law, read the first substantial question. The first one.
Bheda, appellate court can dictate the genuineness of the valid registered deed fully proved by the scribe himself and found real, valid, genuine by the client.
Yes. There is a valid execution of deed, right? That will not prove that there was a ceremony for adoption. A deed has been executed, it has been registered.
Yes, sir.
People went to the registry office and they have executed. Right.
It will say after the 1 year of the ceremony. The
Yes,
the
after 1 year of the ceremony,
Yes, Lord.
right? But ceremony is required to be proved.
That is not proved here.
No. By virtue of registered deed, the ceremony does not stand proved. Now, even if it is assumed that the execution of a registered deed is proved, that will not prove the adoption in Santhal law. That will prove the adoption in Hindu law. Hindu law में दिखाइए. आप ऐसे समझ in Hindu adoption.
Sense is documentation.
संथाल में तो प्रूव करना पड़ेगा, ऐसे थोड़ी होगा ना? इनको भी दीजिए। Section 16. Under Hindu Adoption and Maintenance Act, there is a presumption if there is a registered deed of adoption. Correct? But there is no such presumption in Santhal law. So what has to be proved is the actual physical taking and giving and taking of the ceremony. Right? Who has proved it? So even if the execution of the deed is proved, where does it take you? It is of no relevance. Tell me.
Basis of PW1 to 3 also is proved.
The appellate court has, where is the finding of the appellate court doubting the genuineness of the this deed? वो तो पढ़ लिया. What is the name of PW3?
Rajak Viswas. Rajak Viswas.
Okay. You just read internal page 7 of the appellate court statement.
It is mentioned here that the plaintiff has
PW. Yes,
not
in
needed in the plan.
Yes, read it from here. It is to be mentioned.
It is to be mentioned here that the plaintiff has not pleaded in the plan in the adoption took place by the ministry. As oral proof on the adoption has examined 4 witnesses, including himself. They are PW1 Shankar, Shiv Shankar Viswas, PWT Pradhan, Sanatan Asda, P is the Abdul Razak Viswas, 8 is the plaintiff himself. Besides, then the plaintiff has examined more, 3 more witnesses, but their evidences are most formal, not at all on the specific point of the plaintiff adoption. Besides oral evidences, the plaintiff has filed registered deed of adoption, the Exhibit 1, said to be executed by the Munshi on 16/12/73. The PW1 and 2 are the plaintiff co-villager. Their common evidences is that Munshi, having no son, had adopted the plaintiff as son, and in the adoption ceremony, this was observed with all the necessary local customary function of the adoption like Nimdi, Levet, They were present to witness the same. PW has observed that the Munshi adopted the plaintiff about 17-18 years back, and after a year adoption, Munshi executed the deed of adoption. Exhibit 1, PW 1 and 2 have further disposed that plaintiff's birth name was Mandal Murmu, and at the time of the adoption, the ceremony there was held Namakaran ceremony also, or in that he was named as Vidhumbu. They have further disposed that after adoption of the plaintiff came to be recognized as Munshi son, and after the latter death, he inherited his property and came in possession thereof. PW3 is also the scribe of the Exhibit 1. The registered deed of adoption had been also proved. Its execution by the Munshi Murmu, PW8, the plaintiff also on the oath has supported his plea. Those apart, PW5 have been examined to say that Jaska Murmu, the father of the plaintiff, and Vijay are old, mad, 80 years, and incapable to come to the court and depose. And so there are 2 affidavits, 3 and 8, we support the plaintiff case of adoption have been tendered formally as evidence for the plaintiff. It is these oral evidence of the PW1 to 3 supported with the deed of adoption, Exhibit 1, and 2 other affidavit, Exhibit 3 and 3/8, learned submit judge has placed reliance on the accepting the plaintiff case of adoption and beginning the suit.
पढ़िए पढ़िए.
But the learned council in the appellate plant defendant has several points to see the
To shake the veracity and credibility of the oral as well as documentary evidence of the patent.
of the planting and to assess the finding of the trial court under the impugned judgment and degree with regard to the planting adoption. As referred to above, the planting has examined only two dependent witnesses, namely P.W. 1 and 2, to only testify the factum of the alleged adoption. P.W. 1, although as villager of the planting,
A co-villager of the patent.
we co-villager of the planting, but he is the not a man of his caste or sept. He
He is non-tribal.
is also mentioned by caste. The planting is the Santhal. The planting is a Santhal. It is normally the caste people or people of the sept who are the generally united and they generally tending the family function like the adoption. Moreover, P.W. 1 which are admit at para 6 that is the inhabitant of the different tola of the village Tarapur, where he belongs to the tola same, the planting and his alleged adoption father, adoptive father belongs to the tola Manji. According to his evidence, there are about 70 families of the Santhal in the village. Here is this caste mainly Vedas are only 3 or 4 families. So it is strange that the intended is adoption ceremony and Parakar, where about this evidence he has indicated that therefore this occasion also he has because some cases against the plant is in this background that the remnant plant council has argued that his witnesses carries bias against the plant union and he stands as witness always against him. PWP of the is of course a Santhal, but his evidence contradicting the evidences PW1 at Parapur, he has said that the function of the adoption Nai, Barbara Nai, has also role to play, role in the role nor in the relevant function of the planting. Adoption Barbers was called against this PW1 has stated that PW10 that on the said occasion the barber is usually called and in the relevant function Nai had come to attain the function as had cleared his beard. Moreover, he also at para 3 has admitted that in the past he has deposed against a plant. According to PW1, PW2, adoption ceremony of the plant was held with 17 years back, year being the examining the year 90.
You see, the ceremony has not been proved by you. As per the findings of the learned first article. Correct? If the learned first appellate court records that the ceremony was not proved, then what is the value of this registered deed of adoption? For Santals. It's a very, very pertinent and direct question.
The adoption is registration of the document. Proved the
Registration of the document will prove the adoption? No.
The adoption ceremony is done.
No.
That is a formal.
No. Adoption has to be proved by evidence. There is no parallel law like Hindu Adoption and Maintenance Act that if there is a registered deed of adoption, there is a presumption of adoption, of valid adoption. No. That principle will not apply. There are so many contradictions and there is no substantial question of law on this. Right?
But the dependent first party is also not told the document exhibit 1 is false.
It is not a matter of forgery. The person will go. Just a moment.
They have pleaded in the
No, no.
written statement also.
The point is that the document has been executed. The adoption deed has been executed. But the point is that adoption deed by itself will not prove the adoption. The adoption has to be proved by showing that these ceremonies were performed.
Several witnesses say 70
No, but that is not the substantial question of law here.
70 years back has been ceremony has been done.
That is not the substantial question of law. The substantial question of law all is related to the registered deed of adoption. The adoption will not, let us assume that yes, there is a registry, the people have executed the registered deed, there is a presumption that persons had gone to the registry office and the deed was executed.
Several witnesses say the ceremony has been done.
No, several witnesses have said that ceremony has been done, there are contradictions, there are discussions by the learned court, and the learned court has not believed your adoption. The ceremonies have been performed. Show me the finding of the learned first appellate court that the ceremonies have been proved. Is there any finding? That the ceremonies which have been performed has been proved? Rather, there are contradictions. Somebody says 17 to 18 years back, others say 6 to 7 years back. And in the deed of adoption, there is no date of adoption. In the plaint also, there is no date of adoption.
In the community of Santhal, they are uneducated.
Uneducated means what? Is there any exemption of uneducated person? Date is not important.
Date is important, but the accurate date is not.
Accurate means what? For everything you will say they are illiterate.
If not, I will say.
Then it is date of adoption is a very material date. And there are contradictions. Somebody says 6 to 7 years back. Somebody says 16 to 17 years back.
Only one witness is.
That is enough.
Only one
That is
witness-
enough.
Only one witness is.
Your witness is contradicting themselves. Then when the ceremony of the adoption has not been duly proved, the registered deed of adoption is of no use for Santals.
1, 2, 3 will be 4 years. Para
And these two
para nine of
persons-
the- para nine of the.
And the mother of the natural mother of the plaintiff has also not been examined. Why has she not been examined? The natural father was bedridden. He could file an affidavit before the court. Why commission was not taken for his cross-examination or examination or whatever? No steps were taken.
The objection is not raised. Then
Objection need not be raised. Objection need not be raised. But his cross-examination is important. He being not produced in the court.
I have not challenged this
The most important thing is the ceremony of adoption, the date of adoption. These things have not been proved, and your witnesses have been disbelieved by the court.
Indian I don't challenge the order of distribution of the 380 by 1A evidences produced by the
Sir, where is the finding of the appellate court on the point of ceremony of adoption? फाइंडिंग दिखाइए आप हमको, बस उतना भर का फाइंडिंग दिखा दीजिए, बाकी हमको आपसे कुछ नहीं पूछना।
अगर पेज 9 पर देखे कहीं अगर मिडिल से हम पढ़ते हैं, मिडिल पार्ट पेज 9
हाँ
पेज 9 का मिडिल से पढ़ते हैं, जो सेंटेंस शुरू होता है अकॉर्डिंग टू दाहिने तरफ से ठीक मिडिल की
According to DW1
plaintiff the adoption was held
कहाँ से पढ़ेंगे सर बताइए? According to
the plaintiff the adoption was held 6 to 7 years prior to the deed of adoption
पेज नंबर 9
पेज 9 में appellate court का पेज 9
ऊपर से लाइन काउंट करके बताइए,
मिडिल पैराग्राफ
लाइन काउंट करके बताइए,
जी
लाइन काउंट करके बताइए।
लाइन काउंट करते हैं। अच्छा
हाँ।
ठीक 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15वां से मिडिल में सेंटेंस शुरू होता है अकॉर्डिंग टू द प्लेंटिफ। उसके पहले ही पढ़ सकते हैं अकॉर्डिंग टू 4-5 लाइन
According to PW1
according to PW1 and 2 the
हाँ.
adoption ceremony of the have you also
yes yes आप
plaintiff was held 17 to 18 years back, they being examined in the year 1990. The year of adoption according to them comes to 1971. It is contrary to what the plaintiff has deposed at paragraph 5 of his evidence. According to the plaintiff, adoption was held 6 to 7 years prior to the deed of adoption was executed. Exhibit 1 was executed in the year 1973. So, according to the plaintiff, the year of alleged adoption comes to 1967. So, the evidence of plaintiff PW1 are inconsistent when the alleged adoption took place, and they differ by 5 years. The plaintiff is absolutely silent in his pleading as to when the adoption did take place. It is in the above background that the learned appellate court has rightly pointed out that the evidence of learned appellate counsel has rightly pointed out that the evidence of PW1 and 2 are not worthy of relying on the factum of adoption when the evidence of PW1 and 2 are shaky and not worth relying. The interested oral testimony of plaintiff PW8 is no significance. According to the evidence of PW1, paragraph 10 and PW2, paragraph 4, the main witness who attended the function where Hiru, Robin, Ratan, Raska Hemram, Jogin Murmu, Jatu Hemram, and Vijay Hasta. Apart from them, according to PW5, Hiru Besra, Ratan Hemram, Robin Jogon are dead. Vijay Hasta, Raska Hemram, father of the plaintiff, is very old and incapable to move. So only the affidavit of Vijay, ये peculiar है, affidavit है, so the pleader commissioner बाहर होता है, वहाँ जाके उनका evidence होता है. So only the affidavit of Vijay Hasna and Razga Hasna, Hemran, Exhibit 3 and 3A have been tendered in the evidence by the plaintiff. The learned appellant's counsel has assailed Exhibit 3 and 3A, saying that in the absence of direct testimony of Raska and Vijay, their affidavits cannot be legal evidence to testify the alleged adoption. I find the force of argument if these two witnesses are old and incapable of move, the plaintiff ought to have taken commission to the spot to record in the testimony. So the oral statement, the affidavit is the plaintiff is on affidavit. The written statements are on affidavit. The pleadings are supported by the evidence. Only affidavit will not do. Therefore, merely affidavit is no piece of evidence. So oral statement in the affidavits cannot go in the formal way. I guess उसमें तो क्रॉस एग्जामिनेशन होना होगा, उनका एफिडेविट आने से तो नहीं है. How they will be tested? Two witnesses being tested on cross examination. It will be found that the learned trial court at paragraph 10 of the judgment had discussed the evidence of the two affidavits, Exhibit 3 and 3, which supports the plaintiff's case of adoption and had illegally accepted and relied upon the two exhibits as legal evidence. In my view, the evidence of two affidavits are absolutely worth rejecting and they cannot be accepted.
Yes, we have seen it. Now you tell us, all the three substantial questions of law have been framed on the registration of the registered deed of it,
Yes.
right? तीनों उसी से related है.
Yes.
अगर ये सारा कुछ registered deed of adoption, even if the registry is proved, it doesn't take him anywhere.
Yes. Even if it is registry is proved,
It cannot be said
cannot have
that the adoption
actual
was right.
adoption had taken place.
Because there is no parallel law
Yes.
as that of Hindu adoption. and
No, certainly not.
It is still for him to prove
And
that
apart,
the ceremony had
that
taken
apart,
place.
you also should kindly take pain to see this deed of adoption. I have got a time
Yes,
of it.
exhibit number 1.
हाँ, deed of adoption. इसका
Yes.
रिसेप्टर देखा जाए.
Yes, exhibit 1.
जी. जरा भी नहीं लगता कि ये तो जस्ट टेक्निकल वे में एक एफिडेविट करा दिया कहीं हो रजिस्ट्रेशन हो. विदित हो कि मेरा औरस जात और भी संतान संतानादि नहीं है, तीनों इसमें अलौकिक कार्य संपन्न हेतु पुत्र का रहना आवश्यक है. उपरोक्त उल्लेख सहोदर धाता के पुत्र यानी भतीजा होता है. ये चरित्रवान कर्मठ बालक है. उसे मेरा बहुत पसंद है. पुत्र बुद्धू मुर्मू को पुष्पितर रूप में पाने के लिए सहोदर धाता उक्त बुद्धू मुर्मू ही रह गया है और उसको भी बिल किया है लर्नेड एपेलेट कोर्ट ने कि कहीं उसका नाम भी चेंज नहीं हुआ. वोटर लिस्ट में भी उसका जो नेचुरल फादर है उसी का नाम रह गया. वो दोनों थिंग्स हैव बीन डिस्कस्ड बाय द लर्नेड धाता रस्का मुर्मू से आज ये यदि हम बुद्धू मुर्मू को पुष्प दें तो मेरा मनोमिलास पूर्ण हो जाएगा. उन्होंने मेरा अनुरोध को जानते हुए अपना स्वीकृति दी. हम अपने संथाली प्रथानुसार बुद्धू मुर्मू को ग्रामीण विशिष्ट की परिस्थिति में उनका नाम नहीं मेंशन कर रहा है. सारा कारणीय कार्य लवे अचूर हलवा देख मनिंद समान पूर्वक को उस पुत्र के रूप में ग्रहण किए। तत्काल सब मेरे बीच से लालित पालित होता आ रहा है, लेकिन हमेशा कोई लिखित कागजात नहीं रहने के कारण भविष्य में तुमको कष्ट का सामना करना पड़ेगा। इसलिए मैं वो सूत्र कर सभी को विस्तार घोषणा करता हूँ। इसमें कहीं भी नहीं हुआ है कि कोई मैंने जो ये तो रजिस्टर्ड हो रहा है, एक्चुअल गिविंग एंड टेकिंग का कोई सब
उसके बारे में कुछ है ही नहीं।
साइलेंट है, कंप्लीटली साइलेंट। लेखधारी मुर्मू मृत्युकालीन सारा कार्य करने का उत्तराधिकारी बने। आज से मुर्मू मेरा पुत्र रूप से घोषित हो गया। इससे मेरा मैं अन्य
आज से कैसे रजिस्टर्ड डेट ऑफ रजिस्ट्री से थोड़ी डिक्लेरेशन होगा। The adoption will be relating back to the date of
कभी
adoption.
एक डेट तो होना चाहिए। The plant भी completely
इसमें year of adoption भी नहीं है।
कुछ नहीं। स्थान कहाँ क्या हुआ?
And rather it says that आज से बुद्धू मुर्मू मेरे पुत्र रूप में भूषित हो गया।
पहले जो किया सो क्या हुआ?
आज से from the date of registry.
ये तो इनसे ही nothing is
कुछ है नहीं है।
simply
बताइए कुछ है तो बताइए, हम आपको रिव्यू करेंगे।
लेवल चूर के जो नियम है उसको उसमें पालन किया गया, उसमें लिखा हुआ है। लेवल चूर ही लेने
आपका ये रजिस्टर्ड, आप हमको खाली इतना बता दीजिए, आपने 3 सब्सटैंशियल क्वेश्चन ऑफ लॉ बनवाए हैं, उसमें कोई सेरेमनी के ऊपर कोई सब्सटैंशियल क्वेश्चन ऑफ लॉ बना है? नो,
होना चाहिए था।
there is no substantial question of law on the point of ceremony.
सेरेमनी हुआ है उसको प्रूव किया है और अपडेट कोड भी किया है।
Finding का है appellate court का that the ceremony has been performed. Is there any finding?
फाइंडिंग है उनका
क्या finding?
ये भी डिमांड पर है।
Exhibit 1 पे बात नहीं है, उसके अलावा independent witnesses have they proved that the ceremony has been performed? The appellate court is saying that all the evidences are contradictory. And the deed of adoption does not give the date of adoption, does not mention about any ceremony, and the deed of adoption says that from the date of deed of adoption he will be your adopted son.
इनका डॉक्यूमेंट इनका केस
चलिए हो इतना दिन से लड़ रहे हैं लिखेगा। सेकेंड अपील नंबर 85 ऑफ 1995 विद ब्रैकेट पी है पटना और द लर्निंग काउंसिल अपीलिंग ऑन बिहाफ ऑफ द पार्टीज। This appeal has been filed by the plaintiff.
फादर का नाम कभी बदला ही नहीं, ये भी पैराग्राफ
15 में
पेज 14 में लास्ट में पढ़ा जाएगा। इसमें The second such glaring circumstance is Exhibit D, a certified copy of the voter list of Mahaspur constituency, so and so, village Tarapur, booth number so and so, the voter list number prepared in 1988. In this public document also, plaintiff has been shown as son of Roskamuru, his natural father, had it been the adopted son, Musi Muru, the reference of adopted father should have been appeared in the
Sir, allow back.
D.
This appeal has been filed by the plaintiff. Against the judgment and decree dated 5/7/1995, passed by learned Additional District and Sessions Judge Pakur, entitled Appeal number 22 of 1992/2 of 1994, whereby the learned First Appellate Court has reversed the judgment and decree dated 31/7/1992, passed by learned Subordinate Judge Roman 2 Pakur, entitled suit number 49 of 1988. The suit was decreed by the learned trial court, and the First Appellate Court reversed the decree. Consequently, the plaintiff is the appellant before this court, who has been substituted during the pendency of this case. At the outset, the learned counsel for the respondent has referred to order dated 25/2/2003, pointing out that the appeal has abated as against the proposed legal years of deceased respondent number 1 on account of non-compliance of order dated 25/2/2003, and has further referred to order dated 1/5/2003, passed by this court, which has recorded that incompetency of the appeal on account of its abatement in connection with deceased respondent number 1 will be considered at the time of hearing. The learned counsel submits that these orders may be taken care of by deciding the appeal. The learned counsel for the appellant has submitted that in spite of the fact that the respondent number 1 was not substituted and the appeal has abated qua the legal years and successors of respondent number 1, but still the appeal has not abated as a whole. And he submits that the case be decided on the basis of the substantial question of law which has been framed by the order dated 23/2/1998. The 23/2/1998 which are as follows. इसको कोट करना है तीनों substantial question. the learned counsel has placed the trial court as well as the appellate court's judgment and has submitted that the original plaintiff had filed the suit seeking a decree declaring that the plaintiff is the legally adopted son of Munshi Murmu and a further decree declaring right title interest of the plaintiff over the suit land. The plaintiff further sought a decree seeking confirmation of possession of the plaintiff over the suit land in case the plaintiff is dispossessed during the pendency of the suit. A relief was also prayed for recovery of possession. The suit property was JB number Jamabandi number 10, standing in the name of recorded tenant Jhunka Murmu. The learned counsel for the appellant, while assailing the judgment passed by the learned first appellate court, has submitted that the factum of adoption was duly supported by the registered deed of adoption dated 14/6/73. डेट बताइए.
16,
Dated
16,
deed of adoption. Exhibit 1.
within bracket exhibit 1. Date exact बताइए.
चौदह छः 73.
14/6/70, 1973. He has further submitted that two affidavits were also exhibited before the court, which were exhibit 3 and 3/A. ना पुराना कागज हो गया है सर. Executed by Raksha Hembram, within bracket the natural father of the plaintiff. ध्यान देंगे, गलत नहीं. Natural father है ना, रक्षा हेम्ब्रम.
रस्का
रस्का
मुर्मू.
रस्का हेम्ब्रम लिखा हुआ. Just a moment.
मुर्मू होगा, मुर्मू
Exhibit check.
और फॉर्मा डिपेंडेंट नंबर कौन सा है?
रस का हेम्ब्रम लिखा हुआ है, एफिडेविट में भी रस का हेम्ब्रम लिखा हुआ है।
यहाँ जो प्लेट पर देखते हैं तो यहाँ जो डू किया हुआ है रस्ता में मुर्मू, रस्ता मुर्मू लिखा हुआ है इसमें। ऑफिस कॉपी ऑफ
रस का हेम्ब्रम लिखा हुआ है,
सुदीप को लिखा हुआ है।
एफिडेविट में भी। Exhibit natural photometer, Exhibit 3 and 3 by A, which were affidavit of Raska Hembram, son of late Jata Hembram, and Vijay Hansa, son of late Chunnu Hansa. Who had duly supported the factum of adoption, which according to the affidavit had taken place in the year 1973, according to Santhal customary rituals. He also submitted that the plaintiff had also produced Exhibit 2 to show that, which is the rent receipt, which are the two and 2 by A, which are the two rent receipts, to show that he was in physical possession of the suit. The learned counsel submits that these documents were exhibited without any objection. The learned counsel further submits that in view of the aforesaid materials on record, the factum of adoption was duly proved, but the learned first appellate court erred in law in reversing the judgment passed by the learned trial court by referring to the first substantial question of law. He submits that the scribe of the registered deed of adoption was examined as PW3, and therefore the appellate court could not doubt the genuineness of the registered deed. The learned counsel has submitted that the learned counsel, while referring to the second substantial question of law, has submitted that merely because the identifying and attesting witnesses have not been proved, has not been examined, the registered document with regard to the adoption could not have been disbelieved, inasmuch as the scribe himself had deposed before the court with regard to the registered deed of adoption. The learned counsel has further submitted that merely because, with respect to the third substantial question of law, has submitted that merely because no particular date was mentioned in the adoption deed regarding the adoption which had taken place some years back, thus by performing the required ceremonies of adoption, the same was not fatal to the case of the plaintiff, and would not invalidate the deed of adoption. और कुछ बोलना है इसके अलावा आपको? That is your entire argument, correct? The learned counsel appearing on behalf of the respondents while referring to the substantial question of law has submitted that merely because the registered deed has been executed, the same has no bearing in this case, inasmuch as the plaintiff was required to plead and prove the factum of adoption. He submits that the parties are governed by Santhal law, by the customary law of Santhals, and the learned first appellate court has disbelieved the evidence with regard to the factum of adoption by performing the ceremonies. He has also submitted that though under Hindu Adoption and Maintenance Act, the execution of a registered deed of adoption carries a presumption with regard to its genuineness of adoption. But there is no such law with regard to adoption under the Santhal tribe. The learned counsel submits that the learned first appellate court has considered the inconsistencies in the evidence of the witnesses produced by the plaintiff, and thereby the plaintiff has failed to prove the factum of adoption. The learned counsel has also placed the deed of adoption, registered deed of adoption, which in bracket Exhibit 1, and has submitted that even as per the registered deed of adoption, there is no date of adoption. Further, there is nothing mentioned as to even the year of adoption. Rather, the registered deed of adoption mentions that from the date of the execution of the deed, the plaintiff was adopted. He has also submitted that even in the plaint, no date or year भी नहीं है plaint में. In the plaint also there is no date and year of adoption. He has further submitted that under the in view of the fact that the parties are governed by tribal law, by the parties belonging to scheduled tribe are governed by their tribal law, it was for the plaintiff to prove the factum of adoption by establishing that the ceremonies with regard to the adoption was duly performed, which the plaintiff has miserably failed to prove, and therefore the learned first appellate court has rightly reversed the decree. The learned counsel has referred to the findings recorded by the learned first appellate court and has also submitted that as per Exhibit D, which was a voter list, the plaintiff was shown as son of his natural father. This itself was enough to show that the plaintiff was not the adopted son, was not given in adoption to Munshi Murmu, and his natural father was, क्या नाम है? Raska Murmu. The learned counsel has also submitted that the exhibit 3 and 3/1 has been rightly refused to be relied upon by the learned first appellate court, inasmuch as the affidavit which was filed by way of exhibit 3 and 3/1 could not be taken to be the oral evidence unless the witness were brought before the court for cross-examination, and in case the witnesses were not brought for cross-examination, the learned first appellate court has rightly observed that a commission could have been appointed at the instance of the plaintiff for their examination while they were for their examination and cross-examination. The learned counsel submits that so far as exhibit 2, that is the rent receipts, are concerned, the same has no bearing on the point regarding the legality and validity of adoption. He has also submitted that if the adoption is ultimately found to be invalid, then the property will devolve upon the legal heirs and successors of Munshi Murmu as per the tribal laws. That is all. Respondent number 1 क्या नाम था इनका? बाबूलाल मुर्मू. The learned counsel has also
पेज 14 में पैराग्राफ 13 में DW8 is a teacher of school where the plaintiff was admitted in 1969. This witness, on the basis of school register, has produced a certificate exhibit B, and according to the school record, it was the plaintiff's father Raska Murmu who took इसको भी डी के ये पेज 14 पैराग्राफ 13 लाइन बी. 15वां लाइन 13 14वां 15
School,
now
ये वाला.
produced a certificate exhibit B and according to 13वां लाइन देखा जाए the register had produced a certificate exhibit and according to the school record it was the plaintiff's father Raska Murmu who took him to the school on 20 April 1969 and got him admitted there. In the school record, plaintiff's father is shown as Raska Murmu and not Munshi Murmu. पाया गया. This admission in school of the plaintiff admittedly took place
The Learned
after
Council has,
1967.
that's it. The Learned Council has also referred to Exhibit B, which has been discussed by the Learned First Appellate Court, and he submits that the same is the register of the school in which the plaintiff's natural father Raska Murmu had got him admitted on 21/1969, which was after 1967 when the alleged adoption, as according to the own evidence of the plaintiff, was held. The Learned Council submits that even after the alleged adoption in the year 1967, the plaintiff was admitted and shown to be the son of his natural father Raska Murmu, and such evidence is glaring to show that the factum of adoption was not at all proved by the plaintiff. He has also submitted that the defendant number one, the respondent number one, Babulal Murmu, was one of the sons of Jetha Murmu and full brother of natural father of the plaintiff as well as adoptive father of the plaintiff. He submits that in the plaint, the plaintiff had also sought a declaration with respect to the right title interest over the suit property, which was recorded in the name of Jetha Murmu, which was recorded in the name of Jhunka Murmu, the common ancestor. The Learned Council submits that on account of non-substitution of respondent number one, the title with respect to the suit property cannot be declared in favor of the plaintiff. And accordingly, the entire suit has abated. With respect to such relief, the Learned Council submits that the question of inheriting the suit property would arise, and the question of वैसे भी तो इनको मिलेगा. the learned counsel has also submitted that the plaintiff, being the natural grandson of Jhumka Mundu, may be entitled to inherit a portion of the property if he is otherwise entitled under the
प्लेंट में टोटल 47 बीघा जमीन 15 बीघा जमीन शेड्यूल में जो है
हाँ
इसका आउट ऑफ 47 बीघा 17 कट्ठा 13 भू the suitable value for 15 बीघा 19 कट्ठा शेड्यूल ऑफ द प्लेन तो 46 बीघा टोटल है झुमका का ये केवल मुंशी के शेयर बढ़ाना चाहता था 15 बीघा तो यहाँ 15 बीघा में तो मुंशी का उनको नहीं मिलेगा
Okay. The counsel submits that the plaintiff may not have exclusive title with respect to the share of Munshi Mungu, his so-called adopted father, but otherwise he may be entitled for a share in the property as per the law governing Santhals.
कस्टमरी लॉ की
He submits that the entire suit is related to adoption and the consequence of adoption with respect to the properties, the alleged property of Munshi Mungu. Previous partition proof हुआ है, उसमें तो कोई वो भी नहीं बना,
हम लोग उसमें कहीं है ही नहीं
उसमें कोई इशू भी नहीं फ्रेम हुआ।
कुछ नहीं वो इशू भी नहीं है डिसीजन कुछ नहीं ट्रैक पर
The learned counsel has also submitted that though a plea of previous partition was taken in the written statement, but there is no finding recorded, no issue was
नो
framed
इशू was
with regard to previous partition, nor any finding has been recorded by the learned courts. Either ways. जी इसको लिखाएंगे, ठीक है? Arguments concluded.
क्रॉस एग्जामिनेशन पर इनका कोई एप्लीकेशन नहीं है
क्या चीज?
थ्री
क्रॉस क्या होगा?
इनका एप्लीकेशन का नहीं
आपका कोई आदमी आके भाई एविडेंस इन चीफ कोर्ट में फाइल होता ना, कोई एफिडेविट लाके क्या क्रॉस एग्जामिनेशन होगा?
नहीं आप प्लेट फाइल करते हैं तो एफिडेविट पर
तो कहते हैं हम उस पर
सुन ली हम लोग
अच्छा एक
application होना चाहिए था।
in response the learned counsel for the appellant has submitted that no petition was filed by the defendant for cross examination
बहस ही
of
वही
the
है।
two persons who had whose exhibits were exhibited as exhibit 3 and 3/1, and therefore the learned first appellate court has wrongly discarded those activities.
इसमें एक तो
Oh,
डिसीजन
just a moment. Please hold on. However, this argument could not be related by the learned counsel for the appellant in connection with any of the substantial question of law framed by this court. इस पर कोई substantial question of law बना ही नहीं है, बात करता हूँ।
एक्चुअल फैक्टम ऑफ एडॉप्शन पर है
अच्छा एक
डिसीजन लिखा दिया जा
Just-
सकता है
हाँ कौन सा?
एक्चुअली ये 1983 AIR 1983 सुप्रीम कोर्ट AIR 1983 सुप्रीम कोर्ट पेज 114 पैराग्राफ
AIR 1983 Supreme Court
पेज 114
114
पैराग्राफ नंबर 19
para 19.
A person who seeks to displace the natural succession to property by alleging an adoption must discharge the burden of that lies upon him by proof
Yes.
of factor of adoption
Yes.
and its validity. The evidence in proof of the adoption should be free from all suspicion and of fraud and so consistent and probable as to give no occasion for doubting the truth.
The
यही तो crux है.
learned counsel
It is
for
not-
the
not
just
only-
the learned counsel for the respondents has relied upon following judgments: AIR 1966 Supreme Court 1427
उसको abatement.
on the point of abatement, AIR 2004 SC
वो
3942
भी है।
again on the point of abatement, and AIR 1983 SC 114 paragraph 19 to submit that the factum of adoption is required to be duly proved by the person who asserts the plea of
That
Adoption.
last time is not related to the tribal matter.
अच्छा arguments conclude हो गया आपका. एक second please hold on. I am dismissing the appeal. I will give the dictation in my chamber. इतना लंबा dictation court में
नहीं
नहीं
नहीं सब नहीं
but the appeal stands dismissed.
अभी जजमेंट ये रिलेटेड नहीं है.
कोई बात नहीं.
कोई डिसीजन
इतना सुनने के बाद एक माइंड तो फ्रेम हो ही जाता है.
ये सेंट हियरिंग इस कोर्ट में मिलता है एक्चुअली.
आप तो करना ही नहीं चाह रहे थे. आज आपका क्या ही होगा.
अब क्या कहें, आपको सच बात बोल दें. हम चले गए थे पटना, वहाँ मेरे बहुत ही क्लोज मित्र के बच्चे का यही.
सर एक चीज बता रहे
तो
हैं,
उसमें
जितना एक्सपीरियंस है आपको इस सिविल लिटिगेशन का, जितना दिन में अपीलान बहस करेंगे उतना दिन में तो आप तैयारी हो जाइएगा.
होते हैं.
नहीं हो जाइएगा, बताइए.
हुजूर का कॉपरेशन मिलता है ये सब देखने के लिए. अब सर चूंकि हम वहाँ पर नहीं देख सके थे, मेरा जूनियर उस पर वर्क नहीं किया.
आप ये बोलिए कि जो 10 साल 20 साल पहले जो आपका सिविल लॉ का एक्यूमेन है अब सब यूज हो रहा है.
अब क्या कहें, हम लोग का घर का बच्चा अभी होने रहा. वही चले गए थे पटना, वो टेकिंग सेरेमनी था पर्सन, वही करा के आए.
चलिए
अच्छा लगा.
चलिए नेक्स्ट कॉल.
Item 3, second appeal 283 of 2004.
हाँ जी बताइए.
में नोटिस इशू हो चुका है. This matter was pending before the Supreme Court and this matter has been notice has been issued.
So again substantial question of law.
Abatement was rejected. Against that order was filed before the Supreme Court.
अबेटमेंट था ना, किसका अबेटमेंट था?
Respondent number 3.
रिस्पॉन्ड नंबर 4 के रिस्पॉन्ड नंबर 3?
3.
कौन सा ऑर्डर था?
13.
ऑर्डर डेटेड
13.
13/10.
13 this 13/10/25. There is tentative date as well it is showing. After notice, the will serve the copy to be responded and tentative date is 22/2006. This is showing from
22/2026.
2026.
Essay number 283 of 2025. A copy of order dated 8/1/2026 has been produced before this court. Passed by the Honorable Supreme Court in special leave to appeal number 33240-33241/2025 passed against the order dated 30/10/2025 in this case. The learned counsel submits that the next date, the tentative next date in the matter is 20/2/2026. Office to track the status of the aforesaid SLP. ये यहाँ लगा देंगे. The counsel for the appellant shall also intimate this court about the status of the SLP on the next date. Close this case on 9th of March. आप तो अपियर हो जाएंगे, अब तो दिक्कत नहीं है अपियर होने में. अपियर नहीं होइएगा तो केस ऐसे ही पेंडिंग पड़ा रह जाएगा. केस करना है तो अपियर होइएगा, तो भागना है तो.
I've already informed my client.
हाँ.
Item 5, second appeal 63 of 2012. Appearance दीजिएगा.
Who is for the appellant? Who is for the appellant in this case? Respondent, you are there? What do you are the plaintiff or the defendant? The appeal, अब तो appellant का भी बहस आपको को करना होगा ना? बताइए. Who is the appellant? Tell me who is the appellant? He is the defendant. Appellant is the defendant.
Yes. And the plaintiff.
अब Mr. अमर कुमार सिन्हा को नोटिफाई करिए. उन्हीं का नाम है ना?
मिस्टर देखें
हाँ? ये अपीयर हो रहे थे इसमें मिस्टर अमर कुमार सिन्हा. हाँ, उन्हीं का नाम फ्लैश करिए. बार-बार वही अपीयर हो रहे थे. कभी के अम्बस्टा दोनों का नाम अपीयर करिए. एक कभी अब्दुल वाहिद भी अपीयर हुए. WHAB. He has lost in both the courts.
Not sure it's a reversal. Try to reduce in favor of me, I can for reversal.
Landlord-tenant relationship.
Not sure what. It's a suit property wherein the both of them are brothers, and the respondent claims that he is the he is the owner of the property, and the plaintiff claims that it's a partition between brothers.
Place the trial court judgment. read para 2 and 3.
The trial court judgment, the respondent slash plaintiff.
No, the case of the plaintiff will be trial court.
The case of the plaintiff in brief is that the plaintiff is absolute owner of the suit land and the building standing thereon described in Schedule 1 to the plaintiff. It is stated that land in suit was acquired by the plaintiff alone out of his personal and exclusive funds through registered sale deed dated 3/1/1979 executed by Jharkhand Mali. It is further stated that plaintiff has been coming in exclusive possession over the suit. The purchase of the suit land plaintiff got his name mutated and accordingly Jamabandi was opened in his name. Plaintiff started paying rent and obtaining government rent receipts. Further case of plaintiff is that the plaintiff constructed a house on major part of the suit land and began to reside in the house constructed by him. As the suit land is self-acquired property of the plaintiff along with house standing thereon. House standing on the suit land was assessed for payment of municipal taxes after assigning Chatra municipal holding number 3A in the name of plaintiff alone and plaintiff alone is paying all municipal taxes from time to time. Further case of plaintiff is that plaintiff belonged to very poor family having limited source of income and so the plaintiff grew of his age. He alone left in his native village in the year 1963 and began to reside and earn livelihood at Chatra by doing barber's job. That is, he established a hair cutting salon at Chatra job. The plaintiff earned money enough through his profession. It is stated that father of the parties died in or about 1994 at native village and their mother is still alive and lives at village Basaya since few years after the death of their. Further case of plaintiff is that the defendant number 1, who is brother of plaintiff, decided to earn livelihood at Chitra and accordingly he sought for plaintiff's permission to reside temporarily in plaintiff's house at Chitra. The plaintiff permitted the defendant number 1 to reside in one room in front of his house temporarily on the date and day of Vijayadashmi of the year 1997 with a clear understanding between the parties that as soon as defendant gets alternative residential accommodation at Chitra, he shall vacate the plaintiff's house. It is further stated that the defendant number 1 established his own independent and exclusive hair cutting salon at Chatra job. It is alleged that defendants evaded to vacate the portion of the plaintiff's house on some pretext or other and finally refused to vacate the same on 25/11/2002. A proceeding under section 144 CRPC between the parties bearing case number 2 of 2002 was drawn and rule was made absolute against the defendants. It is further alleged that
हम करेंगे अपीलेंट का बहस हो गया क्या कुछ
अपीलेंट को कहाँ है डिसमिस
शॉर्ट
करना
पास ओवर कर लिया
कुछ पास ओवर
है
नहीं
कहीं सर यहीं पर थे
बैठे हुए थे मतलब क्या
शॉर्ट पास
अभी कहाँ पास होगा अभी तो इनको सुन रहे हैं आपका फाइल कहाँ है? बस अभी इनको सुनने दीजिए इश्यूज देखिए पैरा नंबर 7 He claimed to be the self-acquired property. They claimed that the property was a joint property, and there was
founded here that it is the self-acquired property of the appellant. Respondent. And both the courts, after discussion, the oral and documentary evidence recorded the finding, and ultimately concurrent findings.
What is the finding with regard to the previous partition?
Previous partition it has been disbelieved. The lordship just see for a moment. Appellate court judgment block. पैराग्राफ 11
नहीं आप जरा सब्सटेंशियल क्वेश्चन ऑफ लॉ देखिए ना अब हम क्या करें बताइए
yes
इसको तो
तो
डिसाइड
उसमें जो findings of fact है whether the findings of the learned court below are vitiated due to not properly consider the oral and documentary evidence adduced on behalf of the defendant. Where is the question of law? It is not a substantial question.
वही तो वो तो हम वैसे नहीं कर रहे हैं
परवर्स फाइंडिंग बोलते हैं या कुछ बोलते
फिर
हैं।
भी परवर्सिटी भी नहीं है, कुछ
नहीं।
वैसा सब्सटैंशियल क्वेश्चन ऑफ लॉ
क्वेश्चन ऑफ लॉ इज
आ गया।
जनरल इन नेचर।
आपका प्रैक्टिस कितने साल हो गया? हाँ, 25 साल के प्रैक्टिस के एक्सपीरियंस से बताइए कि ये जो क्वेश्चन ऑफ लॉ बनवाए हैं ये सब्सटैंशियल क्वेश्चन ऑफ लॉ है? फिर खत्म है कहानी।
उस दिन ही बोल चुके थे, क्योंकि इनको बाहर जाना था इसलिए बोले।
तो बस हो गया, अब डिसमिस कर दें। अब क्या बोलना है?
रिकॉर्डिंग बोल चुके थे।
रिकॉर्डिंग होता है, सबसे बड़ा दिक्कत यही है।
हाँ,
सब
नहीं आपको लिटिगेंट का फाइल पकड़े हैं भाई, आपको जस्टिफाई करना है अपना ब्रीफ ना, ऐसे थोड़ी चलेगा। बताइए, कोई परवर्सिटी दिखाइए इस तरह का है, कोई भी आप हमको बताइए कि दिस पर्टिकुलर एविडेंस इज नॉन कंसिडरेशन या कोई ऐसा चीज जिसका डिस्कशन इज परवर्स, आई विल परमिट यू। इसीलिए हम वकील साहब से पूछे, लिटिगेंट से नहीं पूछे। 25 साल के एक्सपीरियंस वाले वकील साहब से।
ये दिन क्लियरली बोल चुके थे जो, लेकिन फिर भी उनका डीसी तो करें।
उनका भी ड्यूटी और हमको भी आंसर करना ही है। चलिए,
ऑर्डर नंबर 3 लॉर्डशिप।
वो पढ़ लिया अब आप खाली एविडेंस दिखाइए, कौन सा एविडेंस को हम डिसाइड कंसिडर करेंगे तो वो जजमेंट आपका फेवर में हो जाएगा।
The issue framed by the learned trial court lordship.
Yes, sir. Page 6, para 7.
बस पेज उखड़ गया है।
Running page 44.
Para 7 lordship. The trial court judgment. Whether plaintiff had a right title, interest and possession over the suit properties, whether the salary number 46 dated 3/1/97 is illegal and invalid, is the suit maintainable in its present form, has the plaintiff cause of action of the suit, has the suit barred by non-joinder or misjoinder of necessary party, is the suit is barred by law of limitation, adverse possession, waiver, requisition and provision so especially related, is the suit property exclusive property of the plaintiff or same joint property of the party, is the plaintiff entitled to the lordship. The finding is issue number 6 lordship.
Issue number 1 and 7 देखिए ना,
1 and 7.
para 11.
Both the issues are main issues of this suit. According to plaintiff, the suit property is the self-acquired property, and according to defendant, there is a joint family property, and it has been acquired by the father of both the plaintiff and defendant number 1. From the perusal of the eligible food, that is original certificate number 46 dated 3/1/1979, it appears that Shiv Shankar Mali, son of Bhumi Mali, resident of Chatra, transferred the area of 0.004 acres Bari lands situated in Moja Chatra, district Chatra, in favor of the Mahavir Thakur, son of Landi Thakur, the resident of Moja Swenso, who received a consideration amount of rupees 12. From the bare result of the sale, it appears that the consideration money of the aforesaid transfer of the land was paid by the purchaser Mahavir Thakur to the vendor Shiv Shankar Mali on the date of the education and registration of the deed. The case of the plaintiff is that he came at Chatra in the year 1963 and he started barber profession. Later on, he opened a salon at Chatra Chowk. Further, case of the plaintiff is that he acquired the suit property from his self-earning. On the other hand, according to defendant, suit property was acquired by the father of both the defendant number 1 and plaintiff. Therefore, the suit property is a joint family property. According to defendants of the plaintiff and defendant number 1 decided to purchase the same land at Chatra. जिसमें तो मिटा वाली पड़ता है with the purpose of education of their children, recordly apportioned for the dispute land of the Dhiba Mohalla Chatra was acquired in the name of plaintiff, and a small structure Kapda post house was constructed by the parent of the plaintiff and defendant number 1. It is asserted that on behalf of the defendant, the major portion of the consideration money and cost of the consideration were paid by the mother of the both the parties out of her personal earning, and Stridhan property is property. Further case of the defendant is that defendant number 1 Bado Thakur started living in Chatra, and also he contributed the consideration amount in the cost of construction of house standing on the land in the field. The self-acquired property in its technical sense means property obtained by the Hindu without any determinant to the ancestral property. There is no presumption that the family become its joint possesses the joint property or property also. The income of the particular member of the joint family in his separate property, if it has been obtained by his own exertions, shall be in where a suit is brought by a Hindu to recover the property, claim that it is the self-acquired property and the defendants contended it is a joint family property. To render the property a joint, it must be proved that the family was possessed and some property with the income of which the property could have been acquired. The presumption that the property is had of the individual proportionary property could arise only if the family nucleus is proved. In absence of proof of nucleus, the member would only be the co-cession. It is thus an established and concept the mere existence of the joint family cannot be raised a presumption that such family is on joint property. A person asserts that the joint family property has to prove from which such property could be acquired. It is only that such a property could be presumed to be joint, and process of proving such acquisition could shift upon the person asserting such. Applying the above mentioned principle, I find that defendants have come with a case that such property was acquired by the parent of both the plaintiff and defendant, but no nucleus of the joint family fund has been shown by the defendant. According to defendant, major part on the consideration money of the suit property was the mother paid by the defendant number 1 and plaintiff from her personal earning and street hand property, but neither the personal earning of the mother nor the street hand has been disclosed by the defendant in their pleading. DT.12.01.2026 so baby, who is the mother of the plaintiff, and he had stated in para 3 of her examination in chief that land was purchased by his husband on behalf of the joint family from the Shankar Mali. She had not stated that she had made contribution to her earning or through her street and for making payment of the contribution money of the disputed land or of the house constructed over the land.
हो गया बात खत्म यहीं पे कहानी खत्म
There is no pleading.
There is no pleading, and the person who has been examined, she herself is not saying that she has contributed for the purchase of the property.
और वो जो एग्जिबिट है जो पार्टीशन डीड के बारे में बोल रहे हैं, that is the only document filed. तुलसी में का इसी just few
Previous partition.
हाँ उसी के बारे में कह रहे हैं एग्जिबिट है वो प्रोड्यूस किए थे. तुलसी में kindly come to page number 12. और उसमें डिस्कशन हुआ 12 में. 12 right. पैरा 2 तो इसमें बोले थे कि इनको बोले कि आप एक हैंडराइटिंग एक्सपर्ट का पिटीशन दें कि आपकी प्लेंटिव का सही है मेरा क्लाइंट का, तो वो हैंडराइटिंग कर दिए, ऑर्डर भी कर दिए, वो पोस्टेड डिपॉजिट नहीं, वही हुजूर लिखा है.
कहाँ?
ये हुजूर जस्ट 12 का मिडिल में जहाँ मोहर है, सील है,
हाँ.
ये सोल डॉक्यूमेंट मिला सील के बीच में जहाँ पर सील है कोर्ट का, उसके ठीक बगल में this sole document which is the basis of the claim of the defendants in exhibit 1 exhibit A, that is the deed of partition. From bare perusal of exhibit A, it appears that the panchayati was held in respect of partition of the suit properties on 22/10/2002, and both plaintiff and defendants number 1 maintained parcha nominated punches who partitioned the suit property and decided the dispute between the plaintiff and the defendant number 1. it is not out of place to mention here that the plaintiff has denied about his signature, partition deed, and availability of his signature.
Thus,
Thus, it may be noted that the defendants have filed a petition before the court to get examine the signature of the plaintiff available on the deed of partition through handwriting and fingerprint expert. And the petition of the defendant was allowed, उन्हीं का petition, on 26/8/2008, but the defendants have failed to comply with the said direction of the court and did not deposit the cost of the expert. And as such, the improved signature of the plaintiff available on the partition deed, Exhibit B, would not be
कल लिखा था
zero.
evidence included, post for dictation tomorrow. 10:30 बजे आ जाइए.
छोटा सा मैटर इसी हम उस दिन भी बोले थे।
नहीं,
बहुत
यार।
छोटा सा मैटर। हम इसे
लिखा
हर
देंगे
केस
ना
में
इसको, ये सब चीजें
बिल्कुल,
करके क्या करेंगे?
हर केस में फेयरली सबमिट करते हैं, रॉन्ग सबमिशन कभी नहीं करते।
ये बात
हमको डर लगा रहता है कि
किससे?
कोर्ट से भी और भगवान से भी कि गलत बात नहीं बोलना। एक केस के चलते कोर्ट में अपना वैल्यू को नहीं कम करना है।
इसीलिए आपकी सारी बात हम बड़े ध्यान से सुनते हैं.
वो भाई